Good afternoon, everybody who is logged on, and welcome to this session for Law for Community Workers. Today we're dealing with changes to residential tenancy laws. My name is Chris Stone and I'm a team leader in Legal Services Legal Information and Advice Division. That's the team that provides legal advice to the community through our free legal helpline and also through appointments. More of that towards the end of the presentation. But for this webinar, we're very thrilled to be joined by Michael Bampton, who is a Senior Conciliation Officer in the Advice and Conciliation branch at Consumer and Business Affairs. After I cover some housekeeping in just a moment, Michael will be telling us about the role of consumer and business services in this area of residential tenancy laws, and also the role of the head of the office, the Commissioner for Consumer Affairs. Can I begin by recognising that we're hosting this webinar and talking on the land of the Kaurna people. We wish to recognise the traditional owners of the countries where you are all joining the webinar from today, and any First Nations people present in this webinar. We pay our respects to all elders past and present, and we celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their cultures and connections to the land and the waters of South Australia. So just some housekeeping matters. Please use the chat functions in Teams to ask any questions. We'll try and keep an eye on questions as they're coming through, or it may be that we save them towards the end. If you do have any technical issues that we might be able to assist with, please again use the chat function in Teams, and our technical support here will do what they can to assist. If you do need a certificate to prove that you've attended this webinar, please email cle@lsc.sa.gov.au, and that will be available to you on request. Okay, so in today's presentation, in today's webinar, we'll be giving you an overview of this year's changes to the private residential tenancy laws. This now includes tenancies for granny flats, which is an area that I know we get inquiries about from time to time. We're not going to be able to cover every single change in detail. We will cover most of the key changes that are now in place. Do bear in mind that the changes we're discussing do not all apply in the same way to housing trust tenancies or to community housing. Some provisions do not apply at all, or there are exceptions to them. So there are differences here and there. There are also some differences and sometimes similarities for rooming houses and residential park tenancies. We're also going to look at the end at some case studies, time permitting, to help us understand those changes. And at the end, we'll talk about the role of legal services and where you can get further help with any problems that may arise. So let's begin with what is the role of Consumer and Business Services and the Commissioner for Consumer Affairs. And I'm going to, at this stage, hand over to Michael to go into that.
Thank you, Chris. Thank you very much. Good afternoon, everyone. Great that you've all been able to attend today. That's fantastic. Look, the role of Consumer Business Services, and I'll abbreviate that each time, CBS, is to provide advice, conciliation, which is in the form of dispute resolution, and education, as well as being the watchdog for all consumer protection legislation in South Australia. So we take requests from consumers and traders, or tenants or landlords, okay, and we assist all customers, whether they're consumers or traders, who contact our office. The Advice and Conciliation branch, from where I'm from, provide advice, conciliation and education for disputes upon request. ANC is set up to assist consumers and traders resolve their disputes in an alternative dispute resolution setting. ANC is unbiased and has no vested interest in the outcome and just wants to see parties resolve any differences amicably. We do not act or advocate for consumers or traders. We're there to assist, provide advice, educate, and empower people. Note, only the court can compel someone to do something. We don't have that function. Additionally, if we receive a legitimate request, we will contact the other party, and in most instances, the trader or landlord, and try to conciliate to help both parties reach a satisfactory resolution. The Commissioner for Consumer Affairs is responsible for the administration of the Residential Tenancies Act, and the Act refers to forms of requirements approved or determined by the Commissioner, which is why you may notice many forms and requirements are set by the Commissioner.
Thanks, Michael. Now, as we've said, there are changes that have come into place in the laws for residential tenancies. What was the aim of those changes, Michael?
Yeah, thanks, Chris. So with all legislation, from time to time, we need to review, update, amend, change to modernise South Australia's renting laws to bring into line and ensure the right balance between the rights and responsibilities of landlords and tenants.
And those changes have come in stages, haven't they?
Absolutely. So, of course, we've looked at what the immediate priorities were, and what we found was a change in the bond system amount. Then we looked at other priorities, which was solicitation of rent bidding to stop that, limitation to an applicant information as requested. So what we see in the past and our future as citizens of Australia and South Australia is that data protection is a very important thing for government to be involved in, protecting tenant information. So we've looked at that. The changes occurred and we brought in our phase one, tougher penalties. They've in fact gone up 5-fold, okay, from what used to be. New penalties when selling a property, no unreasonable refusal for a number of things, particularly in subletting of properties, and rent not increasing more than once every 12 months. So it gives that safety of tenure for a person so that they have it. And then phase two, the July ones, we'll go through some of those in our slides.
Okay. So moving on, we understand that there have been some changes to the information that can be sought about tenants, and also changes to how long this information can be stored. Can you tell us a bit about those changes?
Yeah, so thanks, Krista. Again, looking at what the priorities were, we looked at data information, data retention, and data gathering. And we found that what was being sought from people was a little bit over the top, some cases, and some of the stories we've heard. So landlords are prohibited from requesting the information prescribed under the new regulations. And again, that's gone up 5-fold. A tenant cannot be asked for or required to provide more than 2 documents that verify their identity, relate to the ability to pay rent, or relate to the suitability of that tenant. In fact, landlords cannot ask for previous tenancy dispute history, financial statements, unless that financial document has been redacted. And if it hasn't, they're not even allowed to look at it. They're supposed to put it back in the envelope and send it back, or destroy it immediately. Medical records, which was being asked for, social media accounts, vehicle registration numbers, the microchip number of their pets, or the level of education, or even the reason for seeking a rental. These things are banned now.
There's a lot of detail there that, that was being requested by the South.
Oh, yes. Yeah. That people wanted passports, Medicare numbers, all sorts of information that once given, you don't know what's going to happen to it. And there was no caveats or knowledge of how that was going to be used, stored, or even protected. So if you were giving it to, say, a real estate agent, you had no idea where it was going to go after that. So this is what we were finding. Yeah.
So moving on to how that information is dealt with.
Yes, absolutely. So we've made it really crystal clear now. A person who applies for a property can give consent for their information to be stored up to 6 months after giving that information, because sometimes you might not get your first property or second property. And rather than giving the information over and over again, you can consent to having it on file for a limited period and have it withdrawn or destroyed at any time after that. If you're an unsuccessful tenant and without consent, it must be destroyed by the person who took it or the company that took it within 30 days.
Mm.
And if I'm successful, then it can be destroyed after 3 years at the end of the tenancy. Okay. And again, we need to know, and that's always a good question for anyone to ask, where does my information get stored? What protections do you have for my information? What happens if it's then devolved to somewhere else? Also, we've changed the abandoned property timeframes from 28 days down to 7 days. Things can be disposed of. So that's good for the landlords.
Okay. Michael, I've seen it's being dealt with by Juliet. There was a question about when these changes to prohibited information came in.
Yep.
Those rules are in force,
absolutely,
as I understand it, as from 1st of July this year.
Correct. Absolutely, okay. Yes.
Good-o. Let's move on. So there are some things that need to be sorted out and ticked off the to-do list at the beginning of a tenancy. So, for example, the payment of a bond and rent in advance, as well as inspections relating to the condition of the premises. So, Michael, have there been some changes in this space?
Absolutely. So, with these changes comes absolute clarity. So all the changes bring a really clear understanding of when and how to do things. So at the commencement of a tenancy, when we're looking at formulating that contract between the parties, certain things have to be done and signed off. So the landlord's responsibility is to make sure that they tick the box and make sure it happens. So, and that, as you said, includes the tenancy agreement, must be ticked off, can lodge their own bonds now. Tenants can lodge their own bonds instead of giving it to the landlord to then transfer to the commissioner. Each tenant under the agreement must now be given an ingoing inspection sheet. So previously, as jointly and severally liable tenants were as if one person, you now can have to give it to all of them instead of one. And the landlord, and this is a really important one, big changes in making sure that the rented premises comply with minimum standards prior to entry. So the law before had to be clean and reasonable prior to entry. Now it has to be clean and reasonable and with minimum standards prior to entry. So if I've got a property as a landlord that's a little bit run down, a little bit ramshackle, I'm actually not allowed to rent that out until I fix it up. And not on a lick and a promise either. It has to be ready.
Yeah. I thought it might be useful for me to point out that, yes, these slides will be distributed to participants subsequent to this webinar. And you'll note in the slides that there are some links. And so when the slides are distributed electronically, those links should be live and will take you to the references on there. It's like on the current screen, there's a reference to a tenant information guide, and there's also the reference to where you can find the residential bond forms online. And there'll be other examples such as that during the webinar that you'll see in the slides. So moving on to proposed sale of premises, Michael. There are some issues there.
Yes, so what we found was that the previous wording didn't lend itself to absolutely make it clear that if I was a landlord and I wanted to rent my place out, but I also had in my mind an intention to sell that property within the first 2 months of any tenancy being entered into, that I had to let people know about that or even divulge. And so it's been made very clear now that a landlord or agent, and this includes a selling agent, advertises a premise for rent. They must display and not conceal the fact that they intend to sell the premises within 3 months after a new agreement has been entered into. So it makes it a lot easier now for a tenant to exit the property if, in fact, this is not divulged or brought to the attention prior to commencement or signing the contract. So it's really important change that landlords and agents have to abide by.
Thank you, Michael. So we've already dealt with I guess, the commencement of the tenancy, and we've just looked at the issue of premises are going to be sold. What about once you're in the tenancy? There's also a lot that can come up during that period. Both the tenant and the landlord, under the relevant legislation, of course, have rights, and there are also responsibilities on both sides. A tenant might need to make some minor changes to the premises, for example, or some changes to the agreement about the use of the premises. Can you tell us about some of the changes in that regard, Michael?
Yeah. So these are some of the groundbreaking changes that are really assisting vulnerable persons, persons that need assistance, and tenants in general. It also helps landlords as well. Okay, so a landlord, and this has been happening since the 70s, agents have been taking photographs of property without really getting consent, of taking media images or images of a person's personal property. That's now been banned, and you need written consent prior to even taking a picture. So it's a real big one. And it's been happening for, well, as I said, 50 years. Inspections are now limited to 4 per year instead of up to 12 per year. And you have to work out how you space those out. A landlord must not unreasonably withhold their consent for minor alterations and additions to a premises. And these are, again, this law is all about communication. So as long as the tenant and the landlord discuss it and they work it out together, then a landlord is not allowed to unreasonably withhold consent. And this comes down to possible handrails or assistance infrastructure that helps a person. And if in doubt, it can always be sorted out through the tribunal. Vulnerable people can now change locks and provide the landlord a key. And we do ask that the vulnerable person, depending on a timing, because there's always timing involved in these things, has to have some sort of evidence, okay, before they go ahead with that process. They've got to be able to say in their mind, before I take this action, can I justify this action in front of the member of the tribunal? If they can, and it's justifiable, then you'd proceed, and with evidence. If you can't say in your mind 100% that, maybe they won't agree with me, it's about that discussion and communication and talking, and that's what we want to see.
Before we move forward into the next subject, Michael, I might deal with a couple of questions
absolutely.
on the chat facility, chat function, on the issue of the information or restrictions on information that needs to be supplied, or information which can be asked for. And so somebody has asked, is there an agency or anybody outreaching or working with the agents to ensure that they know their responsibilities or have falling into line?
Yes. So
in other words, someone's also on a similar tack is asking, is it proactive or is it reactive?
Well,
that's a tricky one.
Yeah, absolutely. Look, I wasn't involved in the first 4 processes of the changes. So I've only come in now to do the training, so I can't answer that one. I'm sorry, but to put those two together, it's our agency, Consumer Business Services, CBS, that is working closely with the real estate industry and private landlords, the Landlords Association and such, and they've had quite extensive training already with their information teacher. He was brilliant. Okay, so they've gone through all that. There was a slight moratorium of time that the Commissioner gave the industry to get in gear their changes. So it was widely advertised and worked out with the real estate industry. So and it's our agency still. So even those that weren't involved in that initial learning or change stage, we're here now and we're here to help.
So, so there has been work done to inform and hopefully educate certainly agents and landlords. And if there are agents or landlords still requiring or asking for information that goes beyond, then a complaint can be brought to CBS.
Or request. Yeah, absolutely.
Sure.
Yeah.
Okay. Let's move on to the next subject, and the issue of pets in tenancies. This is something that gets a lot of people interested,
absolutely,
and in some cases very passionate. And there have been some changes in that regard, haven't there?
Oh, absolutely.
Yes.
So again, if it's an exempt animal, well, of course, that's a given. That's going to happen. If a tenant would like to have a pet in a rented premises, they can request the landlord's approval. It must be done in writing. And we also have an example of, if you would like to do a resume for your pet, we've got examples on the CBS website for that to happen. And a landlord must reply in writing within 14 days of receiving that application, stating the approval with conditions, or even the refusal and reasons for refusal. We'll go through those in a minute. If they do not do this, then it's an automatic application and goes through. Otherwise, approved by default. The landlord cannot impose any sort of payment incentive, or now what they used to call a pet bond, which was a collateral agreement to your residential tenancy agreement. Now can't even ask for that. Okay. So, and as I said, we've got some templates on the CBS website for landlords and tenants in this process to help them move forward.
Yep. And again, there's a link on the slide there that people will see. But there are limits, aren't there? So there are grounds on which a pet can be refused.
Absolutely. So pets exceed the reasonable number. Look, if I'm at a residential premises in suburbia, most local councils, it's governed by bylaws and government regulation, that if I've got more than 2 pets, I've got to get special permission in any event if I was a homeowner, and all these sorts of things. So if it exceeds the reasonable number, you can't do it. So if I've got 10 dogs, I'm going to be in trouble unless I go into a rural property. Even with dogs, it's going to be difficult. The premises is unsuitable, a 1-bed sit, and I want a Great Dane, or I want a huge animal that it's not suitable for the animal, then that can be taken into consideration. Unacceptable risk of health and safety. If I've got an animal that is venomous, so a red-bellied black snake, or some other sort of reptile that bites people or could bite people, then no. Things that contravene a law or bylaw, like strata rules, absolutely have to be taken into consideration. And if the tenant has not agreed to a reasonable condition, so if it's an outside dog, the reasonable condition could be that it's kept outside. But if I'm saying, no, I want my Great Dane inside, or my 2 German Shepherds inside, then this can then be sorted out by the tribunal. Or if the animal is not a pet, it's a rock, I'm treating it as a pet, or whatever it is.
Yeah, and this is one of those areas of law where the concept of reasonable is implied, and many people often ask in various contexts, well, what is reasonable? And the answer that many lawyers will give you is, well, it depends.
That's right.
And it does depend on the circumstances.
Absolutely.
Quite often.
Yeah, so when we talk about a suburban place that's a 3-bedroom home that has on a 1/4 acre, plenty of land, lovely for 1 or 2 animals to be kept there, or a group of chickens or things, as opposed to, as I said, a 1-bed sit place that you're trying to keep 2 Great Danes in.
Yep. Okay, so there is so I've just been directed to a question that's come in, and this is taking us slightly away from pets, but that's fine. Let me just read it out to you. Oh, okay, so there are a couple there. I'll just make sure I've got those. Yeah, so the compliance activities on the info, well, that's started
It has,
already,
yes.
as I understand. And there's the question, when does the moratorium end?
Yes, so it ended already. So we
Yeah,
gave
that,
a 2 week for the real estate industry to
yep.
get their applications into line and make sure that they weren't asking for the incorrect information anymore.
Yeah.
So,
And the other question that's come in, can landlords rent out under minimum standard and reduce the rent? My understanding was some houses are rent reduced and cannot be charged at market rent.
yes, so if we're talking about a house that already has, so this is under the Housing Improvement Act
Yes.
2016, is where they take the standard from. Now, if I have, as a landlord, have a house that's already has a housing improvement order under that legislation on the property, and it's under rent control through that legislation, then I can rent it out because it's already under a rent control. It's already under that legislation. Okay, and because the law is I can't rent it out for more than what is set by that order, by that legislation. So if that was what we're talking about, absolutely, as long as it's already under a housing improvement standards order.
Okay.
Yeah.
We've been asked, and I'm not sure that either of us can answer this, how many South Australian strata titles change their rules in relation to pets?
Oh,
I suspect it's impossible to know that.
yeah, I don't have any data on that.
No,
I'm sorry.
no. It's certainly an issue we get inquiries about here at Legal Services, but we don't have access to the individual rules of every strata corporation in the state, and so it's has to be dealt with on a case-by-case basis.
Yeah, so everything is by negotiation. So if I'm a tenant entering into a strata complex, I get the strata rules up front, so I know what questions I can and can't ask. If it's consideration of no pets, but I know that a strata member in that complex does have pets, then there may be a precedent that I can then say, well, number one has a pet. Why can't I have a pet?
Yeah.
And so there's nothing beyond the realms of negotiation.
Yeah. And one aspect of that is doing your research.
Oh, yeah, absolutely.
So if you are buying into a strata corporation, do your research, read the rules, ask questions.
Oh, absolutely.
Yes.
Yeah.
Okay. Let's move on to the next topic, and excessive and electronic rent payments, and there's been a couple of changes there.
Oh, absolutely. So we've identified again that there have been some excessive increases in rent due to our world experiences over the last few years. Now, a tenant may apply to SACAT and declare that the rent is excessive within 90 days of receiving their notice. Okay. What we advise people to do is, as soon as you get your notice of intent to increase, always go back and discuss. So this law is all about communication. So it really is, hey, oh wow, $250 a week. I think I'm going to go back and talk about that. And then if it can't be resolved at the coalface or between the parties face to face, then SACAT is always there. And now, under that particular section of legislation, section 56, it's been made a little bit easier to apply and to have that reviewed by the tribunal, which is really good. Whereas previously, under the previous, before the change, a person had to satisfy several criterion to even meet the benchmark before they could approve it. So not many applications would ever succeed. It was very difficult to do. But now it's been made a little bit easier for people to actually have that looked at, which is great. And that could be disproportionate, and we are seeing that up to $250 a week for some people, which is, yeah.
We've got a couple of questions coming in on rent, which is perhaps not surprising given the current climate. There is a question about, is there a formula to determine whether a rent increase is excessive?
So part of the criterion under Section 56 that a person had to satisfy was the outgoings of a landlord, the median ratio of rent for the same or similar properties in that area. So let's just pick the Adelaide as an area, so the CBD. So we would look at the same or similar properties together that are being marketed for rent, and if they were, let's say, $500 a week, but you're being asked to pay $1,000 a week, okay, well then that might not be fair and reasonable, or it might be disproportionate. So those things is what they look as a formula. There's no mathematical formula other than people generally say, oh, 10% of what the property is worth. Well, we know that seemed to have gone, again, over the last few years, a little bit haywire.
Yes.
So not an easy one to use. Yeah, so.
Okay. Now there's a couple more questions on the rent issue. This one is really asking about the intent of the legislator, so I'm not sure whether we can answer that, but was there any consideration of including a cap on rent increases, percentage or amount, as part of the changes, or is this being considered in the future or for the future?
Yeah, well, again, we can't answer that for the legislators, but look, it was tabled, it was put as a suggestion. In fact, I may have even put it as a suggestion. But yeah, so whether it's going to be considered in the future or not, all things are on the table, all things are always reviewed and looked at. And this is why we've changed the laws today, to bring in line with the modern standards of what it is. But as we all know, time lags of putting something in place, getting it before Parliament, getting it sorted out, having it happen, and then here we are today is time consuming.
It is, yes. And I guess the other thing that certainly we at Legal Services need to point out to people from time to time is that our role is to tell you what the law is. We don't make the law, nor can we change the law. The people that can change the law are the parliamentarians. So if the changes that have been made don't seem sufficient to you, or you think they're inadequate, or even if people think they might have gone too far, then the people to speak to are the MPs.
Absolutely.
Your local MP would be a starting point. Look, there is one or two more questions. There is a question here about someone thought that rent was not allowed to increase by more than 20%. I don't think that's
it's never been a thing, unfortunately. No.
Maybe one of those urban myths out
there.
Yeah, we deal with lots of those. Is there a web page where the criteria that are considered when determining whether a rent increase is excessive is available?
Yes. So so we can all look up laws. So you just go to legislation.sa.gov.au for South Australian legislation, and it'll give you an easy to understand website for all South Australian laws. R for residential tenancies, straight to residential tenancies, and you can scroll down to section 56, okay, increase of rent, and it's all set out there. So that criteria I was talking about before are just straight out of the legislation.
Okay. One of the problems that certainly used to be an issue for people looking up the legislation themselves was the language of legislation. Do you think that's better than it used to be?
So I came into work for CBS at the inception of this legislation. So in 1995, I was there. And this was one of the first pieces of law for South Australia that was a really easy to read and understand piece of law going through Parliament. So back in the 90s, it was decided that we wouldn't have the first part moving to the second part of the third party, or the second, fourth part. So all that sort of language that you might have seen previously in law was then starting to change. And this was one of the first pieces of law that was really easy to read and understand. So this one, as I said, all about communication, all about ease of understanding.
Excellent. There's also a link that Paul from Legal Services, Paul O'Connor, thank you, has put in the chat column. there's a link to a summary of the considerations. So that I think is a useful summary. I think it's a link connected with SACAT. They have a lot of very useful information sheets on their website.
Absolutely.
Okay, let's move along to the next topic because we've got a lot to get through. Moving to the end of a tenancy.
Yeah.
So they can come to an end for a range of reasons, but a significant change since the 1st of July, however, has been the removal of the ability of a landlord to terminate a tenancy without a prescribed reason, without particular reasons being given. And this might prevent some tenants at least from having to move on from tenancy to tenancy just because the landlord has terminated without giving any reason. Michael, can you tell us a bit about these changes? And there are some new timeframes that apply as well.
Absolutely. Yes, thank you. So it was certainly with the times that we have today recognised that there has to be some sort of measure in place to allow for a more fairer, balanced understanding of how things can come to an end. As we knew, a contract would come to an end and it would finish, and that would be the end of a contract. Now, a landlord must give notice with prescribed grounds or reasons, okay, and they have to be reasonable. And they're quite well set out in the changes. Bringing in line with continuing tenancies, they've now made it from 28 days to 60 days, which brings it in line with notice to increase rent as well. So that can all be married together really nice and tightly. So that's really good. If a tenant does get their notice to move out in that case, they can now give 7 days written notice, not a prescribed form, but just in writing, and they can move on quite quickly. So this was determined and decided because of the housing situation where a lot of people are finding it difficult from transitioning or moving from one to another, so that they can have a little bit of ease of doing so. So this was really good.
So just to clarify that, Michael, so if a landlord has given 60 days notice that they're not going to renew the fixed term tenancy, the tenant can then say, I'm going to leave before the end of the tenancy, and only needs to give 7 days notice of that.
Correct.
Okay.
Yes.
And that will bring to an end their obligations.
Absolutely.
Okay.
Yeah.
Good. That's quite a change.
Yeah.
Okay. Now the issue of the prescribed reasons. That has changed somewhat as well.
Yeah. So a prescribed reason now needed when giving notice for not renewing a fixed term tenancy, okay, of a fixed term, or terminating a periodic tenancy. And those reasons for a termination of fixed term tenancies are essentially the same as reasons to terminate on a periodic tenancy basis. So what we used to have for an open-ended contract periodic, where a landlord could give notice for, and that'll be on the next slide, so we could probably shoot to that one.
Yeah, sure.
Yeah. Demolition, repairs and renovations, occupation for themselves, spouse or family member, or they've entered into a contract for sale. All right. So these are the prescribed reasons that can be given to possession now, but there are also additional ones. So we move to the next slide as well.
Just before we go to that, so if a landlord says, I need possession of the premises, I'm giving notice on this basis, I'm going to demolish the premises, I'm going to undertake renovations, or I want a member of my family to live in there. And notice is given, the landlord can't then turn around and in effect change their mind.
No.
And re-let the premises for 6 months.
For 6 months. But if I do change my mind, then I'm allowed to apply to SACAT with that reason for changing my mind. So I can put my matter to the tribunal and put my hat in the ring and say, well, this is the reason for that.
Okay, so if circumstances do change, then that is possible.
Yes, absolutely.
So a landlord might have had plans to demolish or renovate, but there may be practical and real reasons why those plans.
Local government authority does not approve your application, or for whatever reason can happen.
Okay. Okay, let's move on to the next screen then, because there are, other aspects there.
Yeah. So on the flip side of the coin, now tenants have been given the same opportunity that the landlords have for prescribed reasons in ending a tenancy. But these are the additional ones. If the tenant has been given 2 breach notices and there has breached for the 3rd time, not just with rent, how it used to be, but any same or similar breaches. That's really important.
Yes.
So not just rent, it could be 3 of the same or similar.
Yep.
Failed to pay the bond, which normally you'd sort out at the very commencement of the tenancy. I've got to tell everyone, never leave it till the end.
That would help, yeah.
Kept a pet without authorization. Yeah, even if I had a pet in an ongoing tenancy today, I'd still be advised to make my application and get it in writing so that I'm securing that information and I've got written documentation that allows for it to happen. I would be doing that. Or the tenant induced the landlord to enter into agreement with false representations, and this does happen, or is no longer eligible for a charitable organisation renting the NRAS scheme or educational accommodation.
I was made aware of a situation we were giving advice about where a tenant came in, provided some of the information that they can be asked to provide, but it was found that the information was false, and indeed it involved a forged document.
Oh, goodness.
And that induced the landlord to enter into the agreement. So I think clearly something there.
Absolutely. Oh, what a wicked web we weave.
Indeed. Okay, moving on to the next screen. Yes.
Additionally, or their guest. So not just the tenant. These ones include a person's guest has caused serious damage, caused serious risk to life, health, or safety. So my friend who's come in and might have punched the landlord in the nose. Caused or to be unfit for human habitation or been destroyed, threatened or intimidated landlord, agent, or their employee. So the gardener, sales representative, whoever. It extends to all those people that are agents for a landlord. All right. Use the premises for an illegal purpose, including drug-related conduct. So there's now easier mechanisms for landlords to end it on these grounds alone. So it's made it easier for landlords.
Now, we've got aspects here that are summed up under the heading retaliatory notices and domestic abuse, which is a very difficult area.
Yes and no. Again, it comes down to before I take an action, that action I take, can I justify before a member of the Residential Tenancies Tribunal? Yes. So landlord cannot retaliate if a tenant simply seeks to look at or enforce their rights under the legislation. And the tribunal can declare such retaliation as having no effect. So it can make all sorts of orders, and we're waiting to see what they're going to be.
So for just to butt in, so for instance, if a tenant raises an issue about the condition of the premises or something that's not working and needs to be repaired, and the landlord retaliates by giving a notice, would be an example.
Absolutely, and we see this all the time, unfortunately. So this is where these changes have put into place a mechanism where the parties can either resolve amicably between themselves, seek assistance from either of our organisations, or simply go straight to SACAT and have it determined by the tribunal, which is really good. The mechanisms have been made smoother and easier to transgress through these types of situations. Similarly with where the DV or domestic abuse is a part of the mix, and we've got to stamp that out as soon as possible. If a landlord gives a tenant a notice of termination where there's been subjected to domestic abuse, again, it's now easier to apply to the tribunal to look at the circumstances and have a determination made, whether that's valid or not valid.
We might come back later to mention how legal services or part of legal services sometimes can assist domestic abuse victims in such circumstances. I'm just looking at a question here, Michael. What protections exist around breach notices so that they are not misused? I'm thinking about the types of situations where discrimination might arise against tenants with disability or mental ill health. And the questioner is saying, is there a limit, for example, how frequently they can be used, or how much time people have to respond?
Absolutely. So again, the whole system has been made a lot easier to work through. First is to, when I get something, to talk to the other party who's given it to me. I try and clarify and confirm what it really means, or its intention is. Put it in writing to the other party so there's a record. If it still is not resolved, you can come to our office and talk to us. Again, under Section 65 of the Residential Tenancies Act is about quiet, peace and enjoyment. This then falls into, if a landlord keeps giving notice after notice after notice for no good reason other than it's a little bit, then those first steps take place: talk, write, come to us. And then it may end up in SACAT, and the tribunal can determine whether this has been some sort of abuse or not.
Thank you. Let's move on to the issue of termination by a tenant.
Yes.
Because tenants can now seek termination on certain grounds.
Absolutely. So this is what I alluded to before. Tenants can now, on the flip side of the coin, do the same thing where a landlord has committed successive breaches and third strike. Same or similar, not different things. Okay. The condition of the rented premises has not been maintained or kept to the standards under the Housing Improvement Act. The tenant needs to move to aged, palliative or special care, or even crisis accommodation when we talk about DV and the like, or has been offered and accepted by the South Australian Housing Trust or Community Housing Organisation. It's now easier to end a tenancy without too much trouble. And of course, domestic abuse with accompanied evidence.
Yeah. And there's reference on the screen there to a tenancy terminating 30 days following the death of a sole tenant.
So 79G used to be the tenancy terminated upon death of a tenant where they didn't leave anyone in the property, so they were sole tenant. Now, there's a 30-day limit where the executor or family have got 30 days to sort the affairs out, and that can be reduced by the negotiations between the parties or accompanying notices by other parties to bring that on. So it now, instead of it is absolutely final upon death, it's now that 30-day gap of being able to sort the affairs out.
That sounds a very good idea.
Yes.
Okay. So at the end of the tenancy, there is the issue of bonds.
Yes.
That can arise, and the bonds being paid out. And so what can you say about that, Michael?
Yeah, so this is another great change where, as I said at the beginning, a tenant can now pay to the Commissioner's Office or CBS the bond direct. Okay, and the Commissioner has a responsibility to then tell the landlord, hey, we've got the bond, it's all good. Okay, and also shared payouts. Previously, the Commissioner could not split a bond. So if we had a bond of $500 and there were two tenants, the Commissioner would have to give $250 to each person, or depending on how many tenants there were. Now, the tenants can make applications, say, hey, yes, I'm in a tenancy with Chris, but Chris paid $400 and I paid $100. So Michael wants to get $100, but Chris wants to get $400. The Commissioner, on agreement from Chris and Michael, can now do it in that means, which is really good. Okay. The other thing is the time frame. It's been made a little bit tighter for landlords, but it's a really important thing to do. The landlord must dispute any payment of bond within 14 days. Okay, so it's really important that they get their invoices and what they're wanting to be paid to the Commissioner as quickly as possible. Yeah.
Excellent, thank you. I think we're doing okay on time, so we're going to look at some case studies, which will take us through some of the issues that we've gone through, and how the laws might apply in the context of each case study. So in the first one, a client or a community member has had some negative experiences in the past with private landlords. There's probably many people in that category. They've been offered a new tenancy with the private landlord, but they're finding it hard to trust that they will get the bond back. That's what we're just discussing, if rightfully theirs. What could they do to help ensure that the bond is dealt with appropriately?
Absolutely. So, and look, these are true cases. We get these on our phones almost daily. So it's not beyond the realms of this actually happening. Certainly now, you can pay it straight to the Commissioner's office. Once the Commissioner has your money, it's your money. It always belongs to the tenant. And it's the tenant's responsibility to retrieve it at the conclusion. And sometimes our scenarios like this one, where the tenants had some private landlords in the past who have kept the bond, it's always ended up at the tribunal. So the tribunal's then made a determination. The best advice is, it's your money, your responsibility. When that contract ends, you come and get your money. The Commissioner holds it for you. If you do not think that the landlord is going to lodge the bond, and you want to try and not go to the tribunal because of that, because that's what you have to do, then absolutely now you can lodge it so that it's in trust with the Commissioner's office, held in trust for you for the life of the contract, and then you can come and get it.
Excellent advice. Okay. Moving on to the next case study, we have someone who has recently lost their life partner, and for company would like to get a small, non-shedding lapdog as a companion. How would they approach their landlord about this, and what do you think their chances are of approval?
Well, okay, so with the changes, there's a strong chance of approval, even if you didn't have a pet before. And again, it's all about communication and putting that first foot forward and asking the landlord. And look, we hope that everyone's going to be a good human. And if I knew that this person had lost their life partner, I'd be pulling out all stops to help them in any way I could, and certainly agree. The good thing now is, with the change of the law, the landlord cannot unreasonably refuse.
Yeah. And again, it's that concept of what is reasonable in the circumstances. If this person were saying, I'd like to get an alpaca as a companion and I live in an apartment, probably that's not reasonable.
That could be, yes.
Yeah. Okay. And I think this is the last case study. Someone has been moved from tenancy to tenancy due to landlords selling up. Can this keep happening? How is it dealt with? Is there any way to stop this from happening?
Yeah, look, and this is a true one. This does happen. I've had calls on the line about this. Look, the problem with tenancies and renting is that you don't own the property. You don't have the certificate of title for the property. What you do is a license to reside, okay, and enter into a residential tenancy agreement to live there for a period of time, and with conditions of payment and the like in a contract. It's unfortunate, but houses are bought and sold every day in the world, or in South Australia. It can keep happening. It's dealt with. Look, it's about that going into, and there's no way of telling. I might not want to sell my rental property this week, but the bank may force me to sell my rental property next month. or 6 months' time, or for whatever my reasons or are happening in my life as an owner. So it can happen. How's it dealt with? Again, it's the communication. The more communication that people can do and have, the easier things work out. And I've had tenants on the phone and said, "This is my third one. No, I can't get it right." Is there any way of stopping this from happening? Again, unfortunately not. No one knows whether Michael loses his job and can't afford his mortgage on his house and he has to sell it. These things do happen in real life.
But as you say, that if communication is good between the landlord and the tenant, then at least there is knowledge of what is going on, or forewarning of what is going to happen. We're coming towards the end of our time today, folks, but I wanted to confirm where people can go to get general advice in relation to those issues, and that's certainly here with us at the Legal Services Commission. We operate a legal helpline, which is 1300 366 424, and that's open Monday to Friday between 9 and 4:30. The calls are answered by qualified lawyers that you can talk to get some general advice, some preliminary information, referrals if appropriate. And where appropriate, we can also make appointments for people to actually come in and sit down and talk at greater length about the problem. We also do, at much the same time periods, offer a legal chat facility. So you can go online to our website of the Legal Services Commission and have a chat to somebody in real time. And we do offer translators or translation services where it's appropriate and where it's necessary. I should also point out that part of the Legal Services Commission is the Women's Domestic Violence Court Assistance Service. And there's a separate web link and a separate phone number there that's on the slide. That service is funded to assist women who are applying for either intervention orders as a result of domestic violence and or seeking appropriate tenancy orders through SACAT, and that goes back to the references we've made to domestic abuse or domestic violence. There was, in fact, a question about that. Does the new owner, no, where are we? I think I might need to go back a bit about that, but I think there was a query about the orders that are made in relation to tenancies. Is the tenancy cancelled, or is one name taken off the lease? And I think it can be either or.
Absolutely.
As I say, the Women's Domestic Violence Court Assistance Service is there to assist women who are subject or have been subject to domestic abuse in those circumstances. Just moving on to other areas where people can, or other sources of advice and assistance. Community legal centres in South Australia can offer advice and assistance in that way. They're located around the metropolitan area and also in regional areas. There is also a tenants advice service. Rent Right SA provides free advice and support, and to some degree advocacy at SACAT hearings and appeals. They're available Monday to Friday on the number that's on the screen. There are a lot of resources that can be available to you, and all of these have been put on a slide that will be in the PowerPoint presentation that will be shared. So there are links there to all sorts of fact sheets, some, if not all of which I suspect are prepared by CBS.
Yes.
So we're very grateful for that being available. And finally, legal resources are available from Legal Services, our website, the Law Handbook online, which I'm sure many of you have used or seen, does have a lot of information in very easy to read sections about residential tenancies in general. And I think we've just about come to the end of our time. It's 1:29, but in 30 seconds, Michael, can you answer a question? Are clients meant to pay the sewerage rates on the water bill? What if they have a septic tank?
Yeah.
That's a very specific question.
It is a very good one and comes up quite often. So absolutely, a owner of a property or landlord is always responsible for rates, taxes and levies. So the sewerage rates are part of a tax that are responsible by the owner of the property and can't be passed on.
Excellent.
It's the same as, do I pass, if I'm working as an owner and I pay tax, can I pass that on to my tenant? No.
No.
So think of it that way. No, you can't.
Okay.
So rates, taxes, levies can't be passed on ever. Yeah.
Excellent. Thank you, Michael. Look, we've come to the end of our allotted time. There may be specific questions you have, but I suspect that if you want to follow those up with us here at Legal Services, we would be able to deal with those. Or indeed, if there are questions or queries that really represent a complaint about a situation, I'm sure CBS would be more than happy to assist as well. I'm just going to draw your attention to the next webinar in the Law for Community Workers course, and that is Enhancing Legal Pathways for Domestic Violence Victim Survivors. Again, has some relevance to what we've been talking about. That's on 28th of November at 12:30. Thank you all for your attention today, and thank you to the support, technical and otherwise, from staff here. Thank you, Michael, for being part of this discussion.
It was a pleasure. Thanks, Chris. All the best, people.
Thank you. Goodbye.
Thank you.